If this matter went to the trial,
It did not.
it did not. So it's a case of discharge.
Discharge.
In PV Rudrappa, we have held that where an accused is acquitted and the case is an honorable acquittal, then no disciplinary inquiry. Number one. Number two, a discharge or quashment of the criminal proceedings, discharge of the accused, ABC statement, argument before charge. Discharge of an accused is on a far better footing than a full-fledged trial resulting into honorable acquittal. Second postulate in PV Rudrappa. Now she is saying, Madam is saying that I have been discharged. Then why do you hold the inquiry? Then why do you hold the inquiry?
May I respectfully submit, my lord, on the question of whether discharge would amount to honorable, would at least have the semblance of, would be similar to honorable acquittal or not, my lord. Section 228 deals with framing of charge. It begins, if after such consideration and hearing as aforesaid would mean the rigors of section 227.
Correct.
Only if rigors of 227 is satisfied, the judge can proceed on a presumption that the accused have committed the offense and therefore proceed to frame the charge. It thus becomes a duty cast upon the concerned court hearing the discharge application to treat an application for discharge with all seriousness as Damocles' sword hanging on the head of Damocles' sword. I'm sorry.
Damocles' sword.
Damocles' sword hanging on the head of the accused can neither be taken away nor charge can be framed on the said accused. It thus has tremendous significance in the stage of a criminal proceeding. The apex court in plethora of judgments has considered the role of the concerned court at the time of answering a discharge application. It becomes opposite to refer to the judgment of the apex court in Kanchan Kumar case. Well, after noticing in Kanchan Kumar's case, the apex court notices section 227 as well as section 228. Thereafter, this is what is mentioned. Thus, on a consideration of the authorities mentioned above, the following principles emerge. The judge, while considering the question of framing the charges under 227 of the code, has the undoubted power to sift and weigh the evidence for the limited purpose of finding out whether both proceedings being different, my lord. The disciplinary proceedings are to discipline the employee and this is to punish for an offense.
ಅದೆಲ್ಲ ಕನ್ಸಿಡರ್ ಮಾಡಿ ಜಡ್ಜ್ಮೆಂಟ್ ಮಾಡ್ತೇವೆ ಅಂತ ಅಷ್ಟು ನೀವೇನ್ ಮಾತಾಡಿರಲ್ಲ ಅದಕ್ಕಿಂತ ಮುಂದೆ ಹೋಗ್ಬಿಟ್ಟೇವೆ.
ಅದು ಫ್ಯಾಕ್ಟ್ಸ್ ಜಸ್ಟ್ ಒಂದು ಫ್ಯಾಕ್ಟ್ ಪಾಯಿಂಟ್ ಮಾಡೋದಕ್ಕೆ ಐ ಆಮ್ ಜಸ್ಟ್ ಸೇಯಿಂಗ್ ದಿಸ್ ಆಸ್ ಅ ಪ್ರಿಲಿಮಿನರಿ, ಮೈ ಲಾರ್ಡ್.
ಇದು ಗೊತ್ತಾಯ್ತು. ಇದು ಹಂಗ ಒಂದ್ಸರಿ ಜಸ್ಟ್ ನೋಡಿ ಪ್ಲೀಸ್. ಲೆಟ್ಸ್ PV Rudrappa
please. Apparently it is a form of order used in court martial.
What is meant by honorable acquittal? The idea of honorable
acquittal from SEMA. The idea of honorable acquittal is not easy to define, although it can be illustrated. If an accused is discharged at pre-trial stage,
yes,
or the criminal proceeding launched against him is quashed, there is no difficulty in treating the same as the cases of honorable acquittal for the limited purpose of disciplinary inquiry.
ಅದು ನೀವು ಹೇಳೋ ಜಡ್ಜ್ಮೆಂಟ್ ಅನ್ನು ಕನ್ಸಿಡರ್ ಆಗಿದೆ ಹಿಂಗಡೆ ಎಲ್ಲ. Then we postulated the following. ಮುಂದೆ ಹೋಗಿ.
Within brackets, we are mindful that the question of acquittal comes post-trial.
Correct.
A case of honorable acquittal may arise when after trial the criminal court orders acquittal with any honorable acquittal may arise when after trial the criminal court orders acquittal with any of nearly the following illustratives.
Correct.
1. The accused is falsely prosecuted to seek vengeance or for some ulterior motive. 2. That there is absolutely no evidence to implicate the accused. ಓದಿದ್ದೀನಿ ಸ್ವಾಮಿ.
ಅದಕ್ಕೆ ಅದರಲ್ಲಿ ಕ್ರಿಮಿನಲ್ ಸೈಡು ಇದೆ, ಸರ್ವಿಸ್ ಲಾ ಸೈಡು ಇದೆ. ಎರಡನ್ನೂ ಹೆಂಗೆ ಅಸಿಮ್ಯುಲೇಟ್ ಮಾಡ್ಬೇಕದನ್ನ ಅಂತ ನೋಡಿ ಬರೆದಂತ ಜಡ್ಜ್ಮೆಂಟ್. ಇಫ್ an employee is discharged, even there is no prima facie case to go for a trial also. Kenny's Outlines of Criminal Law, so beautifully an English book on criminal jurisprudence, one of the best books. So there is another book by Smith and Hogan on criminal law, criminal cases and material. Beautiful. Smith and Hogan, very beautiful books. ಅವನ್ನೆಲ್ಲ ನೋಡ್ಕೊಂಡು ಬರೆದಿದ್ದು ಜಡ್ಜ್ಮೆಂಟ್. Anyway, read and come back, madam. Kindly you have to read and come back.
Yes, my lord.
ಅಪ್ಲಿಕೇಶನ್ ಕರೆಯೋಣ. ನೋಟಿಸ್ ಆಗಿದೆ ಈಗ?
ನೋಟಿಸ್ ಆಗಿದೆ ಸ್ವಾಮಿ,
ಆಗಿದೆ.
ನೋಟಿಸ್ ಆಗಿದೆ.
ಈಗೇನು ಅವ್ರಿಗೇನ ತೊಂದರೆ ಕೊಡ್ತಾ ಇದ್ದೀರಿ ನಾವು? ಟ್ರಯಲ್ ಇದಕ್ಕೆ ಪ್ರೊಸೀಡಿಂಗ್ ಡಿ ಆಗ್ತಾ ಇದೆಯಾ ಏನು?
I'm not aware of that, my lord.
Don't have information at all. How many years of practice?
Just 2024 enrolled. Now I've been
24 years?
practicing for 5 years, 5 months.
5 months.
Yeah, my lord.
Wait, we will make one order so that you can enjoy your vacation. Discharge ಇದೆ, interim order as prayed for. First, this interim protection has been granted after hearing ಹೆಸರೇನು? Sonika. Madam, request for allotment of a G category site. Having made the payment,
ಸೇಲ್ ಡೀಡ್ ಮಾಡ್ಕೊಟ್ಟಿಲ್ಲ sir. They have allotted sale deed.
his short grievance of the petitioner is as to non-execution and registration of a due conveyance in respect of the subject site allotted to him under G category. Under G category. First off, are you in possession now?
No possession.
Not possession. Learned counsel appearing for the petitioner submits that there is a constitutional mandate enacted in Article 351 of the Constitution, 351, to the effect that whenever a citizen raises a grievance in writing, it cannot go unnoticed by the authorities that be. First off. Next paragraph. Learned senior panel counsel appearing for the respondent BDA initially resisted the petition, saying that if there is no sale deed, it can be a case of specific performance for which an appropriate suit proceeding has to be instituted and not by writ petition.